I am joined by Supreme Court scholar and creator of Empirical SCOTUS, a website that tracks and analyzes Supreme Court stats, Dr. Adam Feldman. The High Court issued its final rulings of the term last week, delivering a few blockbuster opinions, striking down affirmative action policies, siding with a Christian website designer in a First Amendment challenge to a pro-LGBT law in protest of creating same-sex wedding websites, and also rejecting President Biden's plan to forgive student loan debt. Dr. Feldman will break down the significance of these rulings and highlight some interesting trends he has found in tracking the Supreme Court actions during the 2022 term. Thanks, Dr. Feldman, for taking time to chat with us and kind of break down what we saw this term in terms of what was significant or that you found in trending ways of the court, whether it's opinions or numbers where the justices fall. My first question was something you noted in your Empirical SCOTUS. I think it was like a brief kind of few graphs that I had read that you had grasped just from what you've looked at right now, and it was that there wasn't that many cases that were ideologically a 6-3 divide. Is that because there was less cases heard this term, or what was your grasp of that, or how significant is it, and what does that suggest?
So the number of cases was very similar to last term. So it didn't have to do with overall numbers. The real difference is the frequency with which they split ideologically, and that was really different. We dropped from 14 last term to 5 this term, and last term was probably historically one of the terms with the highest frequency of ideological splits that we've seen in the history of the court. So last term kind of proved a lot of people's thinking correct, that having a 6-3 court really can push ideology, and especially the conservative ideology, because of the makeup of the court to a far degree. This term we saw a lot less of that, and I think the justices probably learned a little bit from last term. They possibly on the conservative end maybe felt a little bit pressured by public opinion and kind of backlash that was had after last term, and some of the really strong conservative opinions in abortion and in gun rights. And for the liberal justices, I think they probably realized that if the conservative justices want to push an agenda, then they can do that because they have the numbers. So it makes more sense possibly to find some middle ground. And so that's kind of what I saw a lot this term.
In terms of middle ground, who did you see, or maybe if there's a couple justices who make up the middle of the court? And then I guess also, were there interesting lineups that you were surprised to see, given that we were talking about, there was, of course, the high-profile cases like affirmative action that was 6-3, but other ones that you thought, maybe there would be, but, say like Justice Jackson might have ended up in the same side as like Justice Thomas or Justice Alito.
Right. Yeah, there was definitely some of that. So we saw, in terms of the groupings that Justice Jackson joined Justice Gorsuch in concurrence in several instances, and that was unexpected because they come at judicial interpretation from pretty opposite points of view. Justice Jackson has, as a district court judge, since it's her first term in the Supreme Court, we didn't have a lot of data to back up, expectations of her. But as a district court judge, from her speaking and from oral arguments, we definitely got a sense that she was much more of a pragmatic justice, a justice that looked at history, but not only history from an originalist perspective, but from an interpretive and informing perspective across time, and not just when laws were drafted. And so, it was really interesting to see those mix-ups. But yeah, in cases like Moore versus Harper, which was really the big election case for this term, it was kind of surprising to see the makeup that blended conservative justice and liberal justices. So what we saw was that Kavanaugh and Roberts were really the center of the court this term. We saw that with their frequency in the majorities. Kavanaugh was in the majority 96% of the time. So almost in every case, Kavanaugh was in the majority, and Sam Roberts was in the majority 95% of the time. So they really had a lot of sway in the direction that the court went, and they didn't always just side with the conservatives. Although in some of the cases that people were probably following the closest, like affirmative action, they did side with the other conservative justices.
Mm-hmm. What justices did you, like you mentioned Kavanaugh and Roberts being in the majority or together, like do they side with each other the most, or are there certain justices that you saw like statistically tend to vote together?
Yeah, so I mean, Kavanaugh and Roberts are the pair that votes together the most. They were last term, they were this term, and part of that just has to do with them both being in the majority so often, and you know they agree with each other. Oftentimes they join each other's opinions. So even when they're both in the majority, they tend to side together if there's a concurrence or something to that effect. If they're not authoring the majority opinion itself. But so we see them together most frequently, but we also see the more liberal justices together very frequently, and that's because they tend to share the similar viewpoints, and when they're in dissent, they tend to be in dissent together. But we see pairs across the spectrum. So Thomas and Alito, who are often at the far right end of the court, side together very frequently. So there, these pairings oftentimes meet expectations. But the two that I follow and that seem to trend most closely are Roberts and Kavanaugh, and then really the justices on the left. And this term, Sotomayor and Jackson tended to together very frequently.
What about Barrett? I saw when I was looking at some of your breakdown, it looked like she might vote with some of the liberal justices. Like I think it was like 75% of the time. Is there what do we know much about where I guess Justice Barrett falls? Like a lot of people kind of align her with Roberts and Kavanaugh. Is that fair?
Yeah, so I mean, so far with Barrett, she's been on the right of the court and somewhat unpredictable in how she's going to vote in a given case. I think a lot of people were surprised that she sided with the majority in Moore versus Harper, with Roberts and Kavanaugh and the three more liberal justices. But she tends to be, to the left of Gorsuch, Thomas, and Alito, where sometimes she's in the majority with the more liberal justices, along with Kavanaugh and Roberts. But even in her, in separate opinions, she tends not to join Thomas and Alito that frequently, because Thomas and Alito while they tend to agree in the votes with the more conservative justices, they often write separately about how they agree, but would go even further than the more conservative justices do in a lot of decisions.
Mm-hmm. One of the things like Roberts is known for, right, with his opinions is, well, I mean, it seems like in the past terms and then this term, even though he shares the middle with Justice Kavanaugh, kind of tries to find that middle ground. And one of the things that obviously the affirmative action case was a 6-3 split, but in it, a lot of people have jumped on his acknowledgement, I guess, of like essays. So schools can't consider race in light of the 14th Amendment is what the court heard. But there was I don't know, should we call it a caveat that students, it was acknowledged that students could write about their race and that type of experience that they have about themselves with college admission essays is I guess my question is that a workaround or some sort of opportunity for colleges to still look at race or consider it in a way? I guess, what is the impact? What did you gather from that?
So let me answer that in two parts, because the first part about Roberts is kind of he's damned if he does and damned if he doesn't, because the left sees him as quite conservative, and I think rightly so. We see in some of the most impactful decisions he decides with the conservatives, but the right, I feel like, is very frustrated with him in siding with the liberals in some high-profile cases as well. Mm-hmm. So I think from the public's perspective, he's not really in favor, or not in the good graces of either the left or the right. In the affirmative action cases in particular, Roberts left a big kind of gap in terms of how this is going to be interpreted. I could see this going to a lot of lower courts now. You're going to see cases of affirmative action decided on the facts to see if, and to what extent universities are using race in their acceptance processes. So what the decision did was essentially say that race and diversity in general can't be a category that's thrown in the mix with other factors like GPA and other types of scores that are used to assess applicants. The essays also are given kind of this separate space. So Roberts allowed that carve out where race can still be discussed as a positive and as a aspect that people might find to affect their ability to perform at the same level as other students. Maybe it had an impact on their lives and their ability to go to, let's say, schools that tend to feed into some of these colleges. So those factors can still go into essays, and frankly, I think that's a big question mark where applicants will still use that, and universities, probably because they've become so accustomed to looking at race among other factors in admissions, are still going to look at that very similarly. They're just going to describe their programs and their admissions processes differently. So this is something that I could see the Supreme Court kind of closing the gap on in future terms, where they might revisit to what extent applicants can use diversity in their essays and how that can be calculated in terms of admissions acceptances. But at this point, it's very vague. So I think it's going to be some interpretation from lower courts, and then the Supreme Court may revisit this at some point in the future.
On that same topic about clarifying the law or having to revisit it, that was some of the questions that people asked when I was reporting about the 303 creative case, the one about the Christian website designer who said that she was challenging a Colorado public accommodations law because she didn't want to provide, I guess, same-sex wedding websites in violation of her First Amendment rights. She said it was her speech rights, also in line with her faith. The court sided with her, but it was written in a way that very much highlighted speech. And I think Justice Gorsuch kept saying, the dissent presented so many different examples, but he said, this case, that's not this case. I think he used the term sea of hypotheticals. So my question to you is, when we talk about this LGBT rights versus First Amendment rights issue, we think of I think of Masterpiece Cake, right? The Christian baker who was before the court previously and had such a narrow win, basically having lower courts have to give him a fair chance, and then he's still litigating this, I believe. And others, like florists, is that the 303 creative case settle anything, or is it something again we're going to have to see revisited?
303 creative did settle to some extent that at least gives folks with a strong religious belief the right to express that belief the way they wish. But the key there is express, right? What is an expressive right? So, website has a creative aspect to it, and that's what I see as the justice's real kind of bite at the apple there. It's what's creative, what's expressive. So the justices seemed willing to hold that in Masterpiece Cake Shop, that there was something expressive and creative about making a wedding cake. And they saw that similarly with creating a wedding website, but they really left it sort of vague as to what extent that can go to. So as you mentioned, the florist case, which is one that, I and a lot of other people that follow the court closely thought that the justices would probably take, because it was pushed so hard by the right and interest groups on the right that wanted Masterpiece Cake Shop revisited. It turned out the Supreme Court denied that case on cert, and very soon thereafter took up 303 creative. So we really don't know what falls under expressive content and conduct at the kind of end of the spectrum, right? Where expression ends and where their creative element really does not extend to. So that's something that's left open that will probably be defined down the road to a greater extent. But we know, for instance, at this point that a wedding website does fulfill that, and so that's going to be extended to cases where the courts and lower courts in particular see that expressive conduct in some kind of creative enterprise.
So, okay, yeah. So we're going to have to I guess see lower courts apply this to other areas that where there could be arguments about whether this is expressive or not, right? Is that kind of the arguments that they're going to have to make, these businesses?
Absolutely. The justices like to create clear lines in some cases where they really want people to know, what is allowed and what's not allowed. But sometimes they do things incrementally, and that's what I see in this case. And frankly, that's what's I see in affirmative action as well, where they don't want to tackle the whole issue at once, but see how the public reacts, see how lower courts interpret this, and then maybe revisit it later on where there's increased confusion rather than causing there to be clear distinctions now, but then they don't have the benefit of seeing how these things may be applied incrementally.
Mm-hmm. What about the last kind of major case that was a 6-3 was the court's rejection of President Biden's plan to forgive student loan debt? I don't know where this is going to go because I believe the president has come out and said that he's going to take a look at, I think it's the Higher Education Act, and see if he can get this through another way. I do recall in the opinion, it looked like Justice Roberts went ahead and kind of mentioned the Higher Education Act. Was there anything in there that was this very much pointed at what he was trying to do through the HEROES Act, or has the court kind of acknowledged? I know there was questions about separation of powers, that sort of thing. Do you think that there's any way the president will be able to find, I guess, a workaround from this opinion that we saw last week?
So this is an interesting area because one of the aspects that the justices have really kind of focused on in the last few terms is administrative agencies' interpretation of laws and the what Congress is saying. So the student loan case really focused on the HEROES Act and what kind of power the Department of Education, Secretary of Education, should have under the HEROES Act, and saw that one, it was focused on COVID relief in particular, and two, that the interpretation was just too broad by the Secretary of Education to allow the student debt to relief in that case. So this is definitely something that could be revisited, but I think that will often, the likelihood will be that we see similar problems because Congress really hasn't spoken to debt relief. And so it'll continue to be this debated subject unless Congress clarifies that and kind of empowers the Secretary of Education more clearly in that area.
Mm-hmm. There were a couple other major cases that I had discussed in various episodes of the podcast. One was, I think you referenced before, I don't know, either in conversation with me now or prior to when we were covering the cases, was the Moore v. Harper case about the independent state legislature theory. It was a big elections case. There was conservative lawmakers who said only state court or only federal court should be able to review what state legislators are doing when they're passing election laws in their states. That was rejected, and it wasn't an ideological divide. And then also there was a voting rights case out of Alabama, looking at a congressional map. I think there was a belief that the court could side with, I guess, Alabama lawmakers, saying that they didn't have to redraw their map to add another majority black district. I guess, and then also, this is a side note, the Groff case, right, about religious liberty and being able to take the Sabbath off. That was a win for, I guess, religious liberty there. They said that employers would have to meet more of a substantial, show more of a substantial cost to be able to deny that sort of request. Those were not 6-3, and I think there was a lot of people that thought, they might be. Were you surprised by that, or what I guess after listening to oral arguments, maybe you weren't, or what you see in the trending numbers? How big of a deal is it that we didn't have those come out, with such a divide?
Right. So, just to make sure that we're clear here, Moore versus Harper was a 6-3, it just wasn't along ideological lines. Right. So the kicker there is that we didn't have that conservative liberal split. And that was surprising. Talking about the election cases, Allen versus Milligan and Moore versus Harper. I think a lot of people were looking back at Roberts and especially his opinion in Shelby County as possibly indicative of how he might vote on Moore versus Harper, or his opinion in Rucher versus Common Cause and how he might vote in Allen versus Milligan. So both in elections and in gerrymandering, he ruled very conservatively to the extent that he was not willing to hold these laws to expand voting rights. So the expectation, I think, was that he was going to move in that direction in the cases this term as well, and he really backed off that platform. So why he backed off is kind of anybody's guess. Maybe he felt some pressure from the public, or maybe he kind of retooled himself, or maybe he really did see differences in these cases this term from what he had found in the past, and possibly he was just looking to bring more the justices on both ends of the spectrum together in his decisions, in which case he was successful in that. So this was definitely not the way that I thought he would go at the outset of the term and during oral arguments. In Moore versus Harper in particular, I thought the possibility, because the North Carolina legislature changed the law in that area after the case was granted on cert, I thought that was something that the justices might throw out and not actually rule on the merits, but they did. So there are definitely some areas where I think the justices, and Roberts in particular, moved in an unexpected direction this term in election and voting rights cases. In terms of the Groff case and religious liberty, and some other cases this term, including Sackett and the EPA case there, the justices on both the left and the right agreed in terms of the outcome of the case. And while they would have interpreted the laws very differently, the outcome that they found was the same. So that was something that I don't think we would have seen last term, and kind of shows ways that the justices found cross connections in cases that I and perhaps others thought that there would be kind of more conflicting views. They actually agreed on what the court should do in the case. They just didn't agree on how the justices should implement, or how the government should implement it based on their interpretation.
Mm-hmm. The last thing I have to ask you, because of course everyone was kind of watching Justice Jackson, it being her first term, was there anything significant that you noticed about her? Do we know more about her, where she falls on the court, her style, anything that you kind of can share with us before I let you go?
Yeah, I mean, first of all, I think her past work experience had a lot of impact on how she identified and personified herself as a Supreme Court justice. So, in oral arguments, she was the most active justice this term. She was the most active justice in their first term of all the justices on the Supreme Court, and was the most active justice, aside from Roberts in a few instances, in the last 30 years during oral arguments. So, I think, although we don't have a kind of causal effect where we can say this led to that, that very possibly her experience as a district court judge in D.C. for a number of years, and having sat on a district court where you're the only judge that's there during oral arguments and writing the decisions, probably did influence her as a justice, and her instinct to be very active during oral arguments. So there's that aspect. She really showed a affinity for history, and in particular for the history of the 14th Amendment and how it should be interpreted. And we saw that in cases like the affirmative action case and like Allen versus Milligan, in instances where that came up. Her view of equal protection seemed very, very clear, and very opposed to some of the other justices. So she seems strong in some of her views that we don't always see there being such clear-cut understanding of how justices feel on specific issues once they join the Supreme Court, mostly because we see justices develop their jurisprudence over time. So she appeared to have kind of more founded views of her interpretation and how the laws should be interpreted and what they mean kind of more so than we've seen with some other first-term justices. We also saw, kind of per expectation that she voted most frequently with the justices on the left, but she was also the justice on the left that was in the majority the most frequently, at 84% of the time. She was there more frequently than Kagan and Sotomayor. So that kind of tells us that she was willing to kind of move towards the middle in a way that Kagan and Sotomayor weren't doing to the same extent this term. And also, joining justices on the right in some instances where it was kind of unexpected. In particular, in the California pork products case, she dissented along with Alito, Roberts, and Kavanaugh. And I think that was a big surprise for people that she would join in a dissent, right, in the separate opinion where you kind of have full discretion of what you can do. She sided with these more conservative justices, in particular Alito, who she disagreed with, most of the time this term. They found common ground as well. So she might be a justice where we see some bridge building. She definitely seems like a kind of more moderate of the liberals, as in her first term. And although we can't infer that much from that, it's definitely something to watch for in the future. And then I think like most first term justices, we should expect there to be some changes in her judicial behavior moving forward and some evolution in her views. But we do have at least a kind of first cut at understanding how she will make decisions on the Supreme Court from what she did this term.
Mm-hmm. I think some people would be surprised to learn that she was in the majority. I guess like some people thought maybe she'd be to the left of Sotomayor, but it turns out she didn't. It wasn't that wasn't the case. This, at least so far, right?
Yeah, no, absolutely. Sotomayor was the justice. I think that was farthest to the left, but that's also based on her history, that she was to the left of Breyer and Kagan for a number of years, and Ginsburg as well for a number of years prior. And so the expectation was she was going to be farther to the left. I think she, was more in the middle this term than we might have expected as well. She was definitely more towards the center this term in terms of her frequency in the majority, in terms of the frequency to which she dissented than we saw last term. So she wasn't as far to the left, and I think that kind of maybe blurred some of the distinctions between all the justices on the left who, really dissented almost to the same extent as one another. So we didn't see that differential as strongly, but I think that Sotomayor could still be seen as the justice farthest to the left. Between Kagan and Jackson, I think is the harder part to say, which justice was kind of more of the moderate liberal this term. So I don't think that's as clear.
Okay, I'm sorry to ask you one more, but that just made me think.
Sure.
So who do you think's who was the most conservative this term? Usually, I think people think of Justice Thomas, but did he stay in that lane?
Yeah, I have to think it was Justice Thomas. I mean, last term, it was kind of a toss-up between Alito and Thomas, although I think, really Thomas with his concurrence in Dobbs and showing how he would go even further than the majority and really look closely at the right to privacy in general, showed his penchant for pushing the right, as far right as it'll go. And I think we saw that with his concurrence in the affirmative action cases this term, where he really wanted to eliminate any vestige of race in the admissions process. So I think in terms of his separate writing is where Thomas distinguished himself even more from the other justices on the right. But I think Alito is a close second in terms of his position on the court and the right of the court.
Well, thank you so much for taking time to chat with us. I know my audience will be interested to hear. I've had a lot of questions about, post-term. What does this mean? So I appreciate you breaking it down for us.
Thanks so much for having me.
Thanks for tuning in to the 13th episode of Court Watch. Now that this term is over and the justices are on their summer recess, future Court Watch episodes will highlight major cases for the 2023 term, which will begin in October. If you have not subscribed yet to this podcast, please do so, and also feel free to email me interesting questions or topics you want explored about the legal reporting world. I'll do my best to answer them during each episode. Thanks for listening, and I look forward to hearing from you all soon. Listen to my podcast, Court Watch, at WashingtonTimes.com or wherever you get your favorite podcasts.